court, non-British.
Thank you, Judge. I am getting into the courtroom. I'm the recording. Telling IC we can start. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-1247, Union of Concerned Scientists, Petitioner versus United States Department of Energy. Mr. Bender for the petitioner, Ms. Carroll for the respondent.
Good morning, counsel.
Good morning, Your Honor.
You may proceed.
Good morning. May it please the court, my name is David Bender. I represent the Petitioner, Union of Concerned Scientists in this case. UCS asked the court to vacate the Department of Energy's March 2020 final rulemaking order that established criteria and procedures for how the DOE will handle and share category of information called Critical Electric Infrastructure Information, or CEII. There are two problems with DOE's rules. First, primarily, DOE had no statutory authority to promulgate CEII criteria or procedures. Congress explicitly gave exclusive authority to do so to FERC and not to DOE.
Is your view then that FERC violated the law by specifically determining not to impose criteria or procedures on DOE?
That's not the basis for the argument of UCS. The problem ultimately was when DOE set its own procedures, it went forth and set its own procedures rather than, for example, incorporating FERC's substantive criteria and substantive procedures.
Well, wasn't FERC the boss of this matter? And did FERC decide necessarily it wasn't necessary to impose regulations upon DOE? And the statute said they had authority to do so if they thought it was necessary.
The statute, I believe, Your Honor, says that FERC will do so. And FERC adopted procedures and adopted criteria. As I read FERC's order, declining a comment by, I believe, the utility industry representatives to set additional procedures applicable to DOE, it declined to do so, leaving it open for DOE to follow FERC's procedures either on its own on a case-by-case basis, or, as I said, to adopt a rule incorporating FERC's substantive criteria, substantive procedures for purposes of designations by the DOE.
I'm not sure you answered my question, counsel, but I understand your point.
Yeah, the UCS also.
Can I ask you about Article 3 standing before you get to the merits? So you've alleged informational injury as a basis for standing. Supreme Court has said that being denied information can qualify as a concrete injury for Article 3 purposes if Congress makes the injury concrete by enacting a disclosure statute giving the public rights to information along the lines of FOIA or FACA or statutes like that. This is not a disclosure statute. This is the opposite. This is a confidentiality statute. It's all about protecting information, and you don't point us to anything in the statute which you say creates a right of access to information?
Right to access to information. Well, first of all, Your Honor, I think that UCS has two kind of categories of injury. One is informational injury, as Your Honor points out, and the other is kind of a burden of accessing the information. That there are, through its rules, DOE created kind of additional hurdles, burdens, both a higher standard that UCS needs to show to have access compared to FERC's rules. There's also a more frequent, unlike FERC's rules, there's no annual kind of clean bill of health to access information. So it's imposing some kind of costs to the organization.
Yeah, I'm not sure you preserved that one. I'll follow up on that, but could you just talk about informational injury?
Sure, thanks, Your Honor. The statute here has kind of dual purpose, or at least balances two interests. One is protecting information, certainly, and the other is to allow sharing for that information.
Not quite. It's allow voluntary sharing, and the voluntariness is relative to the people who have the information. And there's another provision in the statute which says very clearly that nothing in the statute requires people to share information who don't want to share information.
So I'm not sure I follow. So what I'm looking at, Your Honor, is in section D2
Right.
of the statute. It provides that commission, being FERC,
Right.
Shall promulgate regulations necessary to.
And then we go down to D.
Correct. And we get down to D, which facilitates voluntary sharing with and between and by. One is the government, so that's the holder of the information once it's filed, and then sub 6 is where UCS falls. Other entities.
Sure, but you're trying to get information. I mean, you wouldn't be in court. The only time you come to court is if you want information that the government doesn't, or some other, whatever, the owner of the electric facility doesn't want to give you that information. By definition, you're not seeking voluntary sharing. You're seeking an involuntary disclosure order.
I believe what UCS is seeking is information that the FERC would voluntarily share under its rules, but that DOE would not voluntarily share under DOE's rules. And that's the category of information that, by operation of FERC's rules,
Go down to, so we're in 4. Go down a couple of subparagraphs to 6. 6 says, nothing in this section shall require a person or entity in possession of CEII to share such information with any list of people or other person or entity. Any federal, state, political subdivision, tribal authority, or any other person or entity.
Correct. The ability to access information then comes from the overlay of the Freedom of Information Act, which then allows UCS and others, the public, access to information held by the government. And then the question does the information fall within an exception, being, in this case, the CEII statute?
Is your point, counsel, that we have to assume the merits for purposes of standing? And then the question is, why do you have Article 3 standing, even assuming, arguendo, your view on the merits? You don't show any declination of information.
Again, Your Honor, two categories, right? One, and I think we were going to come back to, is the kind of the increased administrative burden of seeking.
We'll get to that secondly. And there's an interesting question whether it's appropriate even to raise that in the reply brief. We have a couple opinions on that. But let's talk about the first issue. Well, you've shown no concrete injury in the case, have you?
So we're showing because at the
in terms of declination of information, even assuming you have a right to the information.
I think that's right, Your Honor, and that's why it was pled as an increased risk. I mean, it was we're anticipating application. The case.
Well, how does that meet standing? Don't you have to show something concrete?
According to the court's obvious decision, a risk, which then interprets the Supreme Court's Clapper decision, a risk of future harm is sufficient to show a concrete injury, and which is what we're looking at in this case. The UCS regularly seeks the type of information that is covered by, or at least the rulemaking order suggests will be covered by a CEII designation by the Department of Energy, in which case UCS will either have to show an affirmative national security interest in disclosing it to UCS, or
this is all very speculative, isn't it? I don't see how that establishes Article 3 injury. And then even assuming you could do that, how do you meet the ripeness challenge?
So, I guess responding to both of those, Your Honor, a future injury is always, in some sense, speculative. But it's nevertheless an injury if there is a substantial likelihood that it will impact UCS. And so in this case, UCS says, through its declarations, as well as its rehearing petition, these are categories of information that UCS regularly and anticipates seeking in the future, and based on its interpretation, will be denied access to under DOE's rules. That's a future harm, but it's sufficient to show kind of an imminent injury to UCS. The ripeness question.
Can I just ask you, counsel, before you get to ripeness, even assuming the declarations are as they say, as you suggest, what about the discretion that's allowed in DOE's rule?
Your Honor, I believe that the question is, would DOE, even if it had adopted FERC's rules, kind of substantive criteria and procedures, couldn't DOE nevertheless deny access kind of under some discretionary room within FERC's rules? And I believe that we've addressed in the reply brief, which is, even if there would be a similar harm under a different interpretation, to meet the requirements for standing, we need to show an injury under the rules that exist, I guess, under DOE's unlawful rule. And that isn't diminished by the fact that there may be an injury, a future injury, similar future injury under a discretionary decision absent the illegal rule. And quickly addressing into my rebuttal, but quickly addressing Your Honor's question about redressability. In this case, the issue posed is the legality, whether or not DOE's rules meet the statutory delegation of authority and whether they are arbitrary or capricious. And that issue is ripe and can be redressed by an order vacating those rules. It doesn't require, and it's not premised on application of them to a particular denial.
But on that ripeness question, you have two criteria. The first is whether you have a pure legal issue as an Abbott laboratory, but the second is have you been harmed? Are you harmed? And that seems quite speculative.
Briefly,
Depends how DOE interprets a request.
well, DOE has already announced in the preamble how it's going to interpret a request, at least to a particular set of information that UCS regularly seeks and obtains, which is the OE 417 form. In the preamble to its final rulemaking, DOE has already announced it is going to exercise it will find
It's what?
that the DOE is, I'm sorry, Your Honor.
I'm sorry, I didn't hear you.
DOE announced in its preamble that it intends to designate OE 417 forms as CEII, which then means UCS no longer has access to those, which they regularly access, absent a high showing of national security interest, which is not required of them under FERC's rules. That's an injury, a non-speculative injury that is.
Why? Until you have a denial of information that you would otherwise get, you don't have an injury, and it's not clear to me you would ever have it. They use the term, they didn't use national security, they used another term that really is synonymous, right?
I see I'm past my time.
Please answer the judge's question.
Thank you. The FERC's rules have a negative determination, a gating criteria, which is just cannot be a national security risk, compared to DOE's rules, which requires an affirmative showing of affirmative national security interest in the disclosure. And there's a gulf between the two, right, where information sharing with UCS is neither a harm nor affirmatively, in advancing the national security interest. And it's that category of information that DOE's rulemaking preamble says, at least as to one category of forms that UCS regularly gets, that it is going to deem them CEII, which is then requires UCS to meet a higher burden and do so each time as opposed to once per year under the FERC's rules. And those are injuries to UCS that are reasonably foreseeable. I mean, it's as DOE's announced, it's going to happen.
Can I ask another question on injury, which is this statute has a judicial review provision governing specific determinations of CEII. This is paragraph 11, and that seems to allow parties to go to district court and seek review of a decision, and it requires the district court to examine the documents in camera to make a decision. So why isn't that good enough to enable you to litigate case by case when there's a concrete dispute about specific information?
Yeah, I see the two as two categorically different. This case involves the standards that will apply and the procedures that will apply in designating, and the section 11.
But when you're in an enforcement action, you can always argue that the standards are unlawful.
It's unclear that we can do that, given the standards are created through a rulemaking order. That's section 825L says we need to challenge in a petition to this court within a certain period of time, whereas
but paragraph 11 says notwithstanding 825L, you can bring the as applied challenge once certain information is designated.
And even if you were right, we've often held in when a regulation is challenged and isn't right, you've satisfied your obligation to come to the court to challenge the regulation. And we would hold it until you had a concrete injury that was right. You know, I think it's Eagle Pitcher which we first decided that. Isn't that correct?
I believe that's correct, Your Honor. There's a procedural difference here as well, which is some of the harm will have occurred to UCS before both the delay and the denial before it can be reviewed under Section 11. And that delay in accessing information that it regularly relies on is an injury separate from the injury of being denied ultimately whether or not UCS has access to the information. So to follow DOE's rules will require a longer delay, and it will require additional showings in the effort to access the information before the decision that's reviewable under Section 11, which is the denial itself.
All right, why don't we hear from counsel for respondent, and we'll give you some time on the phone.
Thank you, Anna.
Yes, counsel for respondent.
Yes, good morning, Your Honor. May it please the court, Sarah Carroll on behalf of the government. DOE and FERC's rules are very similar, far more similar than different, and for that reason, petitioner cannot establish Article 3 standing. Even putting aside the informational interest point that Judge Katsas raised, petitioner can't show a substantial risk or a certainly impending threat that it will be denied information it would have received under FERC's rule. And I think it's important and related to this to clear up a couple of things that my colleagues said that aren't quite right, that make the rules sound more different than they are. So for example, Mr. Bender said that DOE announced that it intends to designate these OE 417 forms as CEII, but that's simply not true. DOE adopted the same substantive criteria for designating CEII that FERC adopted. If you look at the regulatory provision, DOE expressly incorporated the provision establishing FERC's criteria. And DOE made clear in the preamble to the final rule and in its rehearing order that it will designate information by applying those criteria on a case-by-case basis.
So I understand, counsel, your argument that if you put the two rules side by side, there are a lot of similarities. But obviously the department thought it was necessary to promulgate a separate rule. So it wasn't just doing the same thing as FERC. And counsel has pointed to a couple of things in its brief and this morning. And I think you'll have to address those, don't you?
There are differences.
Yeah.
I agree that there are differences. The rules are not identical. For one thing, first, on before I get to the more substantive differences Your Honor referred to, there are, of course, formalistic different changes that need to be made. FERC's rule refers to, for example, FERC's CEII coordinator doing things, and that wouldn't make sense in the context of a DOE rule. But so, for example, this national security provision that's in DOE's rule, this is another one of the things that I wanted to clear up, because I think this is another area in which petitioner is kind of seeing a difference between the rules that isn't really there. It's true that FERC's rule does not include that language, but FERC's rule says that in deciding whether to share CEII, FERC's CEII coordinator is to balance the requester's need for the information against the sensitivity of the information.
Oh, yes, but the department's rule puts the burden on the requester. All right, so that's the difference here, isn't it?
Well, the important clarification that I want to make, Your Honor, is that contrary to petitioner's reading, the department's rule does not require a requester to make an affirmative showing that disclosure would help national security. The requester has to show that disclosure would not hurt national security. But as I think we mentioned this.
Yes, so the answer to my question is yes. The burden is on the requester to show that releasing the requested information would not harm national security, to prove a negative, basically.
I think that's right, Your Honor, but I think that is true of FERC's rule as well. I can't speak for FERC, of course, but I would be very surprised if FERC released CEII without having received what it viewed as adequate assurance that release of the information would not hurt national security.
Excuse me, counsel, as you quite interesting just pointed out, you can't speak for FERC. That raises the question that we asked you to address.
Yes.
Is FERC a necessary party here?
Your Honor, we don't think that FERC is the proper respondent or a necessary party here. I would start with this court's decision in Hoopa Valley Tribe v. FERC, which held that Federal Rule of Civil Procedure 19 addressing joinder does not apply in this court, and instead the governing rule is Rule 15 of the Rules of Appellate Procedure. Which
is silent on the question, which is really silent on the issue.
Right. This court held in Hoopa Valley that the proper respondent under Rule 15 is the agency that issued the order. And here, as I think you noted...
But that's a distinguishable case, isn't it? Because here, the crucial decision was made based on the statute. FERC made the decision that it wasn't necessary to impose the same criteria or procedures on DOE. And that was a Chevron deference kind of question, wasn't it? Whether it was necessary or not.
I agree, Your Honor, that I think a lot of petitioners' complaint here really comes down to what FERC did in 2016 and FERC's decision that it was not necessary to bind DOE with criteria or procedures, but petitioner could have challenged FERC's rule at the time it was issued. Petitioner participated in the rulemaking, did not address this issue, did not file a rehearing petition, did not file a petition for review within 60 days as required by Section 825L.
Now you're suggesting that FERC, he should have challenged FERC, that FERC was a necessary party, even though our rules don't address it one way or another.
Well, I'm saying, Your Honor, that if petitioner was unhappy that FERC did not regulate DOE, petitioner had ample opportunity to challenge what FERC did, but petitioner made clear that they do not challenge FERC's decision. And I think Your Honor is right, that given FERC's decision that it was not necessary to establish regulations binding DOE, DOE was well within its authority to use the discretion that FERC had expressly left it. For example, FERC's rehearing order on its rule makes very clear that FERC does not think that DOE is required to change its regulations or to, or it's precluded from designating CEII in accordance with the statute. And DOE was well within its authority to issue its rule, sort of as a matter of good government, to tell members of the public how it intended to exercise the leeway that FERC had left with it. But
DOE did adopt, at least arguably, your position, the same criteria as FERC had adopted.
Yes,
that's right, as opposed to procedures.
That's right, Your Honor. The criteria are the same. The procedures are slightly different, not very different. And for that reason, as I was saying earlier, petitioner can't establish standing to even bring this statutory argument or any of its other claims because it can't show that these very small differences in the procedures will actually lead to the denial of information it would have received under FERC's.
Well, if I can just go back to the point I'm trying to understand here, is I understand your view, or the department's view, is that these two ways of implementing the statute are really very similar. All right?
Yes. Yes.
But they're not identical. You acknowledge that.
I do acknowledge that.
And in responding, just before Judge Silberman came back to the necessary party issue, you said you'd be surprised if FERC would release documents that are requested without making a determination that this would not adversely affect national security. And that may well be so, but the question here is who has the burden? And you're not suggesting, as I read your brief, that the requesting party would have the burden in submitting a request to prove this negative.
FERC and DOE.
So that bars the request in effect.
So a couple of responses, Your Honor. First, both FERC and DOE require that people requesting CEII submit a detailed written request explaining why they need the information, how they will protect it, how they will use it, and that requires the requester to establish, among other things, that it can take good care of the information. Another important point that I want to note at this juncture is that petitioner did not even mention this national security provision in its rehearing petition before DOE. And this court has made very clear that 825L, the statutory provision under which petitioner seeks judicial review, imposes an unusually strict exhaustion requirement. So having failed to raise this before the agency, petitioner can't press it before this court, but even if petitioner could, FERC and DOE both put the onus on a requester to show that its access to this information won't cause harm.
So I think you make a nice point on the national security argument, but I wonder about the lack of annual designation and that type of thing. I mean, these are going to be very, as I would understand it, fairly burdensome requirements if you're broaching anything that may come close to national security, whether the rule says anything about it or not. I mean, the whole rule is designed to provide protection. So to the extent there are differences, your point, as I understood it, is even if there are differences, for purposes of standing, there's no showing here that any request would be denied under the DOE rule that wouldn't be denied under the FERC rule.
Yes.
And isn't that the major hurdle here for, I shouldn't ask you, but for the PSI petition?
Yes, I think that's one of probably the major hurdle. There are other major hurdles. I'm glad Your Honor mentioned the burden point, because I wanted to be sure to note that petitioner indeed did not make these burden arguments related to standing in the opening brief. Our brief, therefore, doesn't address it because it wasn't raised in a timely manner. But, you know, even if they had raised it, the rules, DOE's rule does not impose a larger burden on, a significantly larger burden on petitioner than FERC's rule would, and I could explain that if it would help the court. But it's also just not preserved. I want to be sure I address any other questions the court might have.
Can you just assume, it's a big assumption, but assume we get to the merits. How do you justify any differences in the designation standards? Statute seems clear as can be that FERC has an obligation to promulgate the criteria and processes for designation, and FERC and DOE may designate pursuant to those criteria and processes.
I want to be sure that I'm understanding Your Honor's question. Are you just asking how we read that language to give DOE authority to issue its own rule, or are you wondering what kind of
its own rules that are different from FERC's?
Right. Well, as I was discussing with Judge Silberman, FERC decided that it was not necessary to bind DOE and that it would be better not to do so in light of differences between their activities and their missions. And so FERC, therefore, left DOE with room to designate CEII through, as it saw fit. And there are minor differences, as I was discussing with Judge Rogers, between the procedures, so not the criteria for designating CEII. But DOE explained that it adopted those differences primarily because DOE receives much of the CEII or claims CEII in its possession through voluntary submissions. So as I understand it, DOE does a lot of cooperative work with outside entities to try to work together to protect the energy infrastructure. And that's something that Congress clearly cared a lot about in the FAST Act. For example, subsection E of the statute emphasizes that DOE is supposed to, that the agencies are supposed to work, to communicate as much as possible with other entities as they can to cooperate on these things. And so DOE did make some small tweaks to its procedures to, I think, in the interest of kind of giving entities submitting very sensitive information a little comfort that, perhaps more comfort that it wouldn't be disclosed without at least thoroughly airing the issues and making sure that disclosure wouldn't pose, big problems. But that is well within the discretion that FERC left to DOE, which is consistent with the statute.
I mean, I understand that's your position, but the statute seems to require DOE to use FERC's criteria.
The way we read that language, I understand your point, Your Honor, but the way we read that language,
your theory has to be that there's some general default grant of rulemaking authority within DOE that they can enlist to supplement the standards that govern CEII. And that just seems very strange when the CEII system is very specific, is self-contained in this statute, has a lot of detail, and contemplates coordination and some degree of hierarchy as between FERC sort of over and directing DOE.
I agree that the statute contemplates that FERC will be, in some ways at least, sort of in charge of the CEII enterprise. And I don't think we would contend that DOE could structure its CEII program in a way that FERC didn't want it to or had told it not to do. But we think that DOE is designating CEII pursuant to FERC's rule when essentially, in its rulemaking, FERC said, we don't think we need to adopt things that would bind DOE, and we're going to leave DOE discretion, and DOE is acting pursuant to that decision.
But your point is, you argue that the criteria that DOE has adopted is the same. That's your position. Only the procedures are different.
Yes, and only slightly different.
Yes.
Right, but the statute at every critical turn talks about criteria and processes together as things that some things are done by FERC and DOE can designate under rules, criteria and per criteria and processes established by FERC.
That's true, but again, FERC in making its rule decided to leave DOE with latitude to make these discussions. And even if Petitioner were right that DOE should instead be applying FERC's very slightly different procedures, not that things would, there's certainly no good reason to think things would come out significantly differently, which I think is relevant to the merits, but also to this.
Brings us back to standing. Okay, thank you.
All right, anything further, counsel?
Nothing unless the court has more questions.
All right, thank you.
Thank you.
So we'll hear from counsel for Petitioner. Give you another 2 minutes.
Thank you, Your Honor. I wanted to address a couple of statements that are incorrect, at least based on my reading from my colleague. The statement that there's no affirmative showing required by DOE's rules in order for UCS to access CEII. That can't be squared with the rule that the agency wrote. Subsection J2 of DOE's rule specifically says a request by a non-federal entity, that's UCS, shall not be entertained unless the requesting non-federal entity demonstrates that the release of the information is in the national security interest. That's an affirmative showing, and the burden rests on UCS to make it each and every time it seeks to access CEII. That's categorically different.
But what about the forfeiture argument?
Your Honor, this issue is the specifics of this rule is a question of access. Who can access and under what conditions? And that was specifically preserved in the rehearing petition at JA 36. UCS says they have effectively no means to access CEII under DOE's rules, unlike FERC. And it was,
So I guess the argument is you may have made the broad statement, but you didn't alert the agency to the specifics that you're concerned about and arguing today before the court.
Your Honor, I believe if you look at the response at JA 10, where DOE responds to this, they cite the specific, they cite DOE's rule, J2, and they cite FERC's, not really the same, but kind of analogous in 388.113G, and compare the two. I mean, it was enough, and FERC's response showed that it was enough to alert it to this difference, and that's why it responded the way it did. See that I'm out of time. Thank you, Your Honor. And we asked that
I'd like to ask one last question. Why did you not forfeit the burden argument? You only raised it in the reply brief.
It's similar to my response to Judge Rogers, which is we raised the inability of UCS to access information once it's designated as CEII in the opening brief. And then as the standing argument was made, that we put more detail to it, and the J2 subsection is more detailed, but it falls within the overall.
Isn't there a difference between denial to information and burden in gaining the information? They're two different concepts, aren't they?
They're related, Your Honor, in that if we can't meet the burden, we don't get the information, and that's the problem.
That's a clever response.
Nothing further. Thank you, Your Honor.
Thank you. We'll take the case under advisement.
Case number 20-5161, Phoenix Herpetological Society, Inc., Appellant versus United States Fish and Wildlife Service, et al. Mr. Coles for the appellant, Mr. Richmond for the appellate.
Good morning, counsel.
Good morning, Your Honor. Frederick Coles III, if it may please the court. I represent the appellant in this matter, Phoenix Herpetological Society, Inc., and we are here to set aside and vacate the granting of a joint motion, basically, by the agency to deny my client a renewal to its captive bred wildlife registration and to deny a second or companion application to export Grand Cayman blue iguana to the Aalborg Zoo in Aalborg, Denmark. We look at this application and take the position that the agency's decision-making process denying the two applications was arbitrary, capricious, and unreasonable. Secondly, we think that the district court upholding of those decisions is factually and fatally wrong, in that there's a lack of transparency as it relates to the process that the agency utilized and invoked in order to deny the applications. And I think there's one central issue that is related directly to both of the applications, both the denial of the renewal of the CBW and the denial of the export. And it has to do with the agency's position that the zoo, meaning PHS, did not meet its burden as to establishing that the founder stock of Cayman iguanas were legally brought into the United States. It takes the position that
Well, let me divide them for a moment. On the export question, why isn't the agency's department's decision that sending 2 blue iguanas to Denmark doesn't satisfy the criteria of the statute because of the genetic problems, given the fact there are no blue iguana in Denmark? Isn't that enough to deny your export request?
We don't believe that it is, Your Honor, based upon the fact that the agency's decision in that regard was not based upon the best scientific information or data. It is true that the Aalborg Zoo does not have any blue iguana in its possession. But the purpose of both the agency and the exporting regulations is to help to propagate the conservation, protection, and promulgation of the species and conservation of the species. The Aalborg Zoo, just like my client, is a well-established zoo. It's capable of raising and breeding the subject iguanas. The agency takes the position that because the 2 animals that are subject to export come from the same clutch, what the agency is doing is comparing the breeding of reptiles to that of mammals and or birds, when the breeding of reptiles it's a different category. The information that was provided to the agency, it cherry-picked information to overlook from the authority that it relied upon, that being Fred Burton, that inbreeding did in fact occur, not only on the island itself in the wild, but also while they had certain iguanas in their protective captive possession, that inbreeding did in fact take place. That's recognized in a couple of emails that are part of the administrative record coming from Fred Burton that were available to the agency to review. The agency chose to overlook that component of the email and instead focused on another portion, that the lack of genetic diversity without any support for such was the basis for our opinion, is the basis upon which they're denying the application. And as much as it's not supported by the facts of the record, and it's not supported by any literature of any type of scientific treaty, we take the position that that decision is in fact unreasonable, capricious, and just flat wrong.
Now, going to the registration question, after you have submitted various explanations with respect to the export, why wasn't the agency legitimate, including, we just don't trust you anymore? You gave 3 different, wildly different explanations with respect to the ancestry of these animals.
If I may, Your Honor, this was an issue that my briefing, when I say my briefing, because I substituted in, as your honors are aware, did not particularly address. The reason why I didn't address it is because there was an ongoing fight from my review of the record between the agency, between another individual named, I believe it's Mr. Schumacher, who my client had originally engaged, certainly a while prior to this particular application. Then there was a brouhaha as to Mr. Schumacher's involvement. Ultimately, my client terminated Mr. Schumacher with regards to the application process. There's also information that Mr. Schumacher gave incorrect information to the agency while my client was in fact hospitalized in ICU as a result of being bitten by a poisonous snake. When he comes out of the hospital, he owns up to the mistake that was made by Mr. Schumacher and bears it himself, and that's how we get to the various explanations that Your Honor asked me about. But from our position, we are consistent in what it is that we're asking for, and we don't believe that those missteps are such that the agency's denial as to Mr. Blair's affidavit should be taken in the same vein.
So let me just follow up a little bit. On the first point that you were discussing with Judge Silberman about the genetic problem,
Yes.
You certainly are correct that Mr. Burton talks about inbreeding happen. But the question that the agency had was not does it happen, as it were, but is this something that's desirable in both the propagation of the species and not harming it? In other words, a different question. Things happen, but that doesn't necessarily mean that's what you want to see happen when it's on your watch.
I think the best way that I can answer Your Honor's question is this. The agency certainly has not pointed to any information, any scientific data, any type of reliable scientific information to say that such inbreeding does not occur in iguanas in their natural habitat, even though these animals are in fact in a conservation program within a protected environment. If it's happening in the wild, the fact that it happens in the wild, and even Mr. Burton acknowledged that it did in fact happen while animals of the same species were in captivity, the agency's position here is not supported by any scientific information to show that there would be a detriment to any animals that were in fact engaged in any form of inbreeding.
So the court defers to the scientific and expert judgments. So I'm just trying to understand, is your position not that the agency was required to acknowledge that there's nothing wrong with inbreeding, but that in order to deny your client's application, it had to point to scientific evidence that inbreeding is harmful to the species?
My position is slightly different than that, and I'm not trying to sort of put it in the realm of engaging in semantics. But basically, our position is there is no scientific information that shows that inbreeding among reptiles, and specifically among blue caiman iguana, is detrimental to the perpetuation, conservation, and preservation of the species in an instance where those same animals are in fact listed as endangered species.
But that's what I'm getting at, that it's listed in Appendix 1 now, and the statute requires the agency to find that this is going to enhance propagation of the species. Can the court say it was wrong to conclude that that would not be consistent with the statutory standard?
I think the court has the authority to conclude that that is wrong if that position by the agency is not supported by scientific information.
Well,
But you understand, though, that you're... Go ahead, who's trying to talk here?
excuse me. Not only is this a scientific question, it's a predictive judgment on the part of the agency, to which we typically defer as well. In other words, if you don't know one way or another, just the risk, as Judge Rogers is suggesting, is a legitimate basis upon which the agency would deny the export license.
I am out of time, if Your Honor. I would like to
Please
respond.
respond. Yeah.
Yes. Our position, and the record supports it, I think it's even acknowledged in the agency's brief, that my client started with initially 4 Grand Cayman blue iguana. And he has grown the population through its conservation efforts to a total of 22 iguanas. There's been no incidents of any type of deformities that have been noted. There have been no incidents of any type of bad behavior problems, deficiencies, or anything with respect to my client's care, conservation, and preservation of these animals. He is now, based upon moving forward with promulgating the species, to assist the Aalborg Zoo in basically engaging in the same course of conduct that it did, which in fact has been successful and is in fact contributing to the promulgation of the species by having increased the number from at least 4 up to 22 and possibly more as we're here today.
So I guess my last question here is, your client clearly had the burden, and you don't deny that. So that while I agree, I don't read any criticism, as you're suggesting, of what your client has done here. The agency was looking at an export to a zoo that has no iguanas. And this inbreeding concern. And given what the statute is talking about in terms of enhancing propagation of the species, why not for sort of expertise and, as Judge Silberman points out, predictive reasons, the agency could reasonably deny the permit?
Your Honor is correct that we do have the burden. I think we certainly, by review of the record, I think that we have in fact satisfied our burden. I think there's an ample amount of information with respect to satisfying that burden as it's addressed specifically in, I believe it's a Silverstein forensic report, which when you look at the agency's denials, there's no reference to that. There's no taking into consideration any of that. There's no refutation of anything that was put forth in that report that addresses the very questions that Your Honor asked. In addition to that, I think what the agency is doing is the agency is creating an unreasonable and an impossible hurdle as it relates to the export of these animals. The agency relies upon the position, well, the Aalborg Zoo has no blue caiman iguanas in its possession. There was a point in time when my client had no blue caiman iguanas in its possession, and yet it has sufficiently added to the number of such animals in existence. Similarly, every facility that's going to engage in a conservation program has to start at step 1. Step 1 is, in fact, the first set of animals that are capable of breeding and assisting in population growth. To deny that opportunity to a well-established zoo, where there's information in the record that certainly shows the criteria and the qualifications of the people who operate the zoo, there's certainly nothing deficient as it relates to their qualifications. And secondly, what the agency is doing without supporting it, but it's sort of implicit in their denials and in their rationale, is they're trying to make and assert and inject into this equation the position that the raising of Grand Cayman blue iguana is somewhat unique and distinct from the breeding of any other type of lizard or other iguana, and the record and the scientific record does not support that position.
Can I ask on the lawful acquisition point? Your brief, as I understand it, you assume on the law that it's your burden to show that the parent stock was lawfully acquired, and you argue on the facts that you discharged that burden. Is that a fair characterization of your position?
just so that we're clear and that I didn't misunderstand your question, our position is that the founder stock came into the country
Right.
prior to the enactment of either the laws in the Grand Cayman here and CITES.
You haven't made the broader argument that that question is irrelevant, is legally irrelevant.
I didn't look at it as a question of being legally irrelevant. I looked at it as a question that was being raised with no basis by the agency.
Because you think you proved lawful import of the parent stock, that they came in before the listing.
Yes, I believe that that my client has sufficiently met its burden in that regard, and I don't think there's anything in the record that contradicts that in any way.
Okay, thank you.
All right, we'll give you some time on rebuttal. Let's hear from counsel for appellees.
Good morning, Your Honors, and may it please the Court. My name is Ben Richmond, and I represent federal appellees. Your Honor, what this case concerns is the denial of two different permit applications, a captive bred wildlife registration and an export permit, both of which pertain to plaintiff's population of Grand Cayman blue iguanas, a species which has been listed under the Endangered Species Act since 1983 and protected under the Convention since 1977. What is really here at the heart of the case is plaintiff's applications for these two separate permits and whether the information submitted by plaintiff meet all of the standards required for the service to grant those permits. So what I'd like to do, Your Honors, is briefly frame up for our benefit the different requirements for each of these different permits. I'll start with the export permit. The export permit was plaintiff's application to export 4 of its Grand Cayman blue iguanas to the Aalborg Zoo in Aalborg, Denmark. For these export permits, there are two groups of findings which need to be made. First, a finding under the Endangered Species Act that the export would enhance the propagation or survival of the species. Then, in the other group of findings for the export permit are two findings under the Convention. That is a legal acquisition finding, that the species to be exported and its parental stock have been legally acquired, and a non-detriment finding, that the animals to be exported would not be detrimental to the species as a whole, and in particular, the species in the wild. The other permit at issue here is the captive bred wildlife registration. And what a captive bred wildlife registration is it allows otherwise prohibited activities under the Endangered Species Act for the purpose of some sort of beneficial breeding program, a captive breeding program designed to promote the endangered species in question. So here there are various findings that need to be made for that captive bred wildlife permit, and those findings cannot be made unless the parental stock of the animals covered by the permit have been legally acquired. So those are all the various requirements. There are 3 that are relevant here for the export permit, and there's 1 really that's relevant here for the captive bred wildlife registration. Now, the burden was on plaintiff, as Your Honors discussed previously. Burden was firmly on plaintiff to provide enough information to allow the service to make these various findings and grant both of the applications. But after 3 rounds of administrative review, that just wasn't possible here, and the service was not able to make these findings that would allow it to grant these permits. I'll briefly talk about the findings that were made on each of these permits here. So beginning with the export permit, I discussed there were 3 findings which were crucial. The service could not make 2 of those findings. It was not able to make an enhancement finding because it determined that plaintiff's final representation that it sought to export 4 iguanas born from the same clutch to Aalborg, Denmark, where it would have no other iguanas for those iguanas to breed with, would not be consistent with genetic diversity. It also made a finding on legal acquisition. As Your Honors discussed previously, there were 3 shifting explanations of the blue iguanas that plaintiffs sought to export. First, it sought to export iguanas from the Life Fellowship in the San Diego Zoo. After that application was denied, plaintiff said it wanted to export 2 pairs of iguanas, one originating from Ty Park in Florida, the other 2 originating with Ramon Noegal. then after that application was denied, there was yet another representation that plaintiffs sought to export 4 iguanas, all from Ramon Noegal. So those shifting explanations here were not credible and cannot be corroborated by a hearsay affidavit, which again, the service was not able to credit because there were serious issues with the credibility of that information.
Well, let me ask you that, yes, Judge Silberman?
Thank you. On the Blair affidavit, part of it was not hearsay, wasn't it? What Blair himself observed or did?
Yes, Your Honor. All Blair attested to as the affiant was that Ramon Noegal had told him that Ramon Noegal had acquired these iguanas in 1971.
That's not all Blair. That's not all Blair did. His affidavit also describes what he did, and that's not hearsay.
Correct, Your Honor. What Blair did himself was not hearsay, but the information about legal acquisition, which is the relevant part of the affidavit that would have been relevant to that legal acquisition requirement, was a hearsay statement.
What about your own investigation, which indicated possibly that Blair was correct?
So, Your Honor, I just want to clarify that the investigation that the service did, it went above and beyond its requirement to review evidence here. It could have just stayed with
right, but it didn't. So
yes, Your Honor.
Judge Silberman is saying it had that information before it.
Yes, Your Honor. So what the service did, which is reflected in its various emails, is it tried to determine whether the Blair affidavit did have any credibility and that account had any credibility. And to do so, it reviewed Ramon Noegal's published iguana research, published in the 1980s, to try to verify if these iguanas, which had supposedly been imported to the United States in the early 1970s, had been present in the United States before the iguanas were protected under law.
And your investigator determined possibly Blair was right.
Your Honor, what the service determined was that there was not enough evidence in that research to show that the iguanas had been in the United States before protection under the convention in 1977. The service, and they not only reviewed the iguana research published by Ramon Noegal, they also talked to Fred Burton and asked Fred Burton to see, who's an iguana researcher with the Grand Cayman Islands government, whether he could corroborate an import of iguanas. And again, there wasn't credible information from Mr. Burton.
Who was the one of your investigators that said it was possible that Blair was right?
Your Honor, I believe that was Fred Burton's recollection in his email. He begins his email by saying, I understand that this may have happened and it is possibly legal. But there were serious issues with his account. So, for example, he mentioned that an individual named Roger Fair had orchestrated the export in what he had heard about this export. And the issue was that the service had information before it that Roger Fair had not arrived on Grand Cayman until the 1980s. And in addition, that account attributing the export to Roger Fair conflicted with Ramon Noegal's recollection, which was that Ramon Noegal himself had captured these iguanas in the wild and shipped them back to the United States in his checked baggage. So these many and different varying accounts were just not enough to show a legal acquisition finding here.
So basically, the agency wants a bill of sale that's been notarized.
No, Your Honor. Any clear information that the iguanas had existed in the United States.
The argument is that the man who Blair referred to is dead.
Yes, Your Honor.
All right, so
I
there's no way to
understand that.
get a direct statement from him. So that's why I say the agency is saying, in those circumstances, we're not going to conclude anything less than a bill of sale.
There's no announcement that a bill of sale is required, Your Honor.
No, but I'm just thinking about the reality of what happened here?
Yes, Your Honor.
You made your own investigation. You had some indication that this probably happened the way people were saying. There were no eyewitnesses. There was no written bill of sale. And you're just not going where somebody's on the Appendix 1, not somebody, but some species is on Appendix 1. There's a very high burden, says the agency, even though the requesting party here has an admirable record and the zoo in Denmark has an admirable record, but it just doesn't have any blue iguanas.
Your Honor, a bill of sale wasn't required. The service looked at the research published by Ramon Newegel in part to try to corroborate that some of these iguanas had just been present in the United States in the early 1970s. Any record from a zoo or research institution that these iguanas were present in the United States would have sufficed. You know, zoos, research institutions, they keep track of the animals in their collection.
No, but counsel, what appears to have happened here is some of these exotic species were being brought in surreptitiously.
Yes, Your Honor.
You don't have a legal trail.
Yes, Your Honor. It appears that that may have been an issue.
The agency decided it was going to issue this rule establishing this program, so what would otherwise be legal activity could be legal, provided all these criteria were met. And if they weren't met in the agency's view, you wouldn't get your permit.
Correct. If an export here is to be done, then that export has to have animals that have been legally acquired, or their parental stock have been legally acquired. That is consistent with the conservation mandates of the service.
You know what occurs to me, counsel? As time goes on, the getting evidence of legal acquisition prior to the effective date of the statute or the regulation, you necessarily are going to rely on hearsay because people are going to be dead.
Again, it's
so are you discriminating against old people?
No, Your Honor, certainly not. So I just want to clarify, you know, the burden here is on plaintiff to present sufficient evidence. And perhaps in some cases, hearsay could suffice. But here there's just no indicia of reliability to corroborate the hearsay statement.
The problem is the fellow who made the comment, Noble, is it? He's dead.
No, I won't.
No, I'm sorry, I'm mispronouncing. He's dead. Isn't that correct?
Yes, Your Honor, yes. And the service, you know, exceeded its burden here to review evidence related to acquisition and tried to find additional corroboration of that hearsay statement, understanding that that could possibly be the best evidence before them. But, you know, when it went looking for that information, the Ramon Newegel published iguana research with its correspondence with Fred Burton, it could not corroborate the hearsay. There was no indicia of reliability which would allow the service to accept that hearsay for the legal acquisition finding.
Why does legal acquisition of the parent stock even matter? The treaty requires that the specimen be lawfully acquired, and specimen is a defined term that means the animal itself, not the animal and go 10 generations back to the beginning of time 4 decades ago.
Yes, Your Honor. So legal acquisition is part of one of the findings under the convention, and in order to put into effect those requirements of the convention, there are rules and regulations. I don't have the specific rule here, but those rules...
Your regulation under the treaty says specimen or parental stock. The treaty just says specimen.
Yes, Your Honor.
I mean, and maybe the short answer is this wasn't challenged, but you may be asking us to uphold an order based on a law that doesn't really exist, or a requirement that doesn't really exist.
Depending on whether the regulation is a proper interpretation of the statute.
Yes, Your Honor. And so because these issues weren't raised below, the service didn't have an opportunity to brief the specific rules promulgated here to carry out the convention. But if Your Honors would potentially like additional information or briefing on that matter, and that issue is raised and somehow, even though it wasn't raised below, we'd be happy to do that.
Okay.
I'm certainly not requesting additional briefing.
Thank you, Your Honor.
Talk a little bit, if you will, about the denial of the re-registration request.
Yes, Your Honor. Thank you for asking that. So the captive bred wildlife registration, the issue there was, again, the legal acquisition of parental stock. And that registration, it was because essentially what was being considered in the captive bred wildlife registration was the entire population of 22 blue iguanas that plaintiff had in its possession. And the service prompted plaintiff to submit that information on the legal acquisition of its parental stock. And through 3 rounds of administrative review, there was no information submitted about the entire population of the parental stock and whether that had been legally acquired.
So let me just be clear. This organization, so far as the record indicates, has a good record. It's not as though it's been cited by the agency over time for violating regulations or anything.
Not to my knowledge, Your Honor.
Well, not in the record before.
Not in the record before.
And I don't think we want to imply that there may be something out there because the agency hasn't presented that. No point in smearing somebody's reputation. Okay. So they've been receiving these registrations for years and have done a good job with this particular species, growing it. But following up on Judge Silberman's point, time passes, people die, they can't get the original owner, so they come up with the best information they have. And it's true, the agency says, well, we can't definitively determine legal acquisition of the parental stock.
Yes, Your Honor.
Is there any different standard for export versus registration?
Your Honor, the regulatory scheme for exports versus captive bred wildlife programs are different. And I tried to describe that a little bit earlier. The finding that's key under the captive bred wildlife registration is provided under 1721G, which is a rule. There are a variety of different findings and factors which the service would ordinarily have to make to grant that captive bred wildlife registration. But those findings can't be made unless the parental stock of the species covered by the captive bred wildlife permit have been legally acquired.
So the question is, what is the burden for re-registration? What I'm talking about is somebody's been operating under your registrations for years.
Yes.
And there's no evidence that they have ever come into a review or investigation by the agency. Now they want to export some iguanas. And they've got a problem. All right?
Yes, Your Honor.
Genetics, apparently, as counsel tells us, there was some fight going on, some misrepresentations were made, but Petitioner owned up to them and hoped to go forward. So I'm just a little concerned that under those circumstances, I mean, what is the status now? Is everything they're doing illegal? Can they be fined? Can they be shut down?
Your Honor, the only real result of the permit being revoked is not having that captive bred wildlife registration for their iguanas. This is not an enforcement action.
I understand that you haven't brought that yet. What I'm getting at is they're trying to run a lawful operation.
Yes, Your Honor.
They've had the blessing of the agency for years. And
yes, Your Honor.
Sure, they don't have bill of sales apparently for every animal in their custody now, these 24 blue iguanas.
Yes, Your Honor. So issues arose about the parental stock of the iguanas in question here, and they arose because of the export application. And now,
excuse me, counsel. To make it clear with respect to Judge Rogers' question, your action so far implicates only the blue iguanas in the stock of the company or the zoo. Is that correct?
Yes, Your Honor. These actions at issue here are only as to Phoenix Herpetological Society's collection of iguanas.
No, but their registration has expired.
Yes, Your Honor.
It isn't limited to the blue iguanas.
I misunderstood. I thought the registration affected only the blue iguanas, not the other animals.
Is that right?
Correct, Your Honor. There were a whole host of different animals listed on the captive bred.
The 24 iguanas, they have no authority to maintain them?
Correct, Your Honor. They're not. I want to be careful about how I answer this question because there are different regulatory schemes at issue here. But essentially, the plaintiff is not licensed to conduct a captive bred wildlife program as with respect to these Grand Cayman iguanas.
What happens to these blue iguanas?
No, what happens to the Phoenix group?
So, Your Honor, the final administrative denial here that was issued by the service prompted plaintiff to work with the service and potentially, submit additional information that could corroborate legal acquisition. But even after that final administrative denial, that's at JA 615.
Counsel, we're curious, what happens to the blue iguanas?
Your Honor, I believe it's in the discretion of the service whether an enforcement action.
To do what?
Potentially enforcement action could be brought. I don't want to speculate as to what the service would do, or the service could try to continue to work with plaintiff to try to get this captive bred wildlife registration renewed, as it prompted plaintiff to do at JA 615.
But counsel, if you still deny the registration, what happens to the blue iguanas?
The blue iguanas are still there. They're no longer. There's no longer an exemption under Section 9 of the Endangered Species Act that would allow plaintiff to collect, capture.
You're not answering the question.
No.
Why can't we be worried about the blue iguanas?
I'm sorry. I'm not sure I understand, Your Honor.
We want to know what happens to the blue iguanas if the registration to hold the blue iguanas is denied.
Yes, Your Honor. As far as I understand now, nothing currently will happen. Plaintiff will still have the blue iguanas. They won't be covered by this permit.
Well, let's try it this way.
Yeah.
Is it assuming the CBW registration is not reinstated, is it presently lawful for them to possess these iguanas?
No, Your Honor.
Wow.
So, therefore, what happens to the blue iguanas? You don't know.
I don't know. It's at the discretion of the agency how it would follow up here.
And why is that? Is that because you understand the verb take to include possession?
Your Honor, Section 9 also prohibits collect.
Clearly, without the permit, they can't export, they can't sell. I get that.
They cannot collect either. That's part of the
Well, but collect can mean acquire. You think it means possess?
Perhaps, Your Honor. And again, we didn't have the opportunity to brief this below. I guess there is a question as you're raising about whether
most nuclear of all remedies. They just shut down. They can't breed. They can't possess. They're out of business.
Well, they're not out of business because I gather they collect or have maintained a lot of different animals.
As to iguanas.
but as the blue iguanas, they're out of business, and that mystifies to me as to what happens to the blue iguanas. You're not going to go out there and kill them.
No, Your Honor. And again, in terms of a remedy or a path forward here, the most beneficial thing to happen would be for plaintiffs to continue to work with the service and attempt to try to corroborate legal acquisition and obtain that captive bred wildlife permit.
And I understand that's the problem, though. The agency is saying, I want a bill of sale. And I know you say hearsay if it's corroborated, but they tried to corroborate it in several ways, and that was not satisfactory to the agency. And that's why I raised the question whether or not the standard under the export permit is different than the standard under the possession in the circumstances where, over the years, the agency has issued these registrations. And this particular organization has been very successful in propagating these blue iguanas. And there's no evidence of any concern by the agency until now. And yet the agency says, well, it's probably wrong in issuing all these previous.
Yes, Your Honor. The agency conceded that at JA 373, that it might have to reevaluate prior approvals. That it might have to... that it may have to reevaluate prior approvals in light of this legal acquisition issue.
They didn't concede anything. They just who is it? It's the Phoenix Herpetological Society in a precarious position. That's all I'm getting at.
Yes, Your Honor. The burden here was on plaintiff to provide sufficient evidence. After 3 rounds of administrative review and working with the agency, plaintiff wasn't able to provide that information.
When was the first registration issued? Back in the early 80s?
No, Your Honor. I actually don't have in the record the registration beyond the one that was set to expire in 2017. So I'm not exactly sure at this time how many previous.
Well, it hasn't for dozens of years is what I'm getting at. The agency comes along with a new concern. Okay. Presumably blue iguanas could go to another zoo that has a registration. But I don't understand how the other zoo can accept them when there's no proof of lawful entry of the parent stock. And under your interpretation, the agency's interpretation, that's what Judge Silberman is focusing on. You have to kill these iguanas. Nobody has authority to maintain them because you can't come up with this bill of sale or this passport. Okay, well.
I'll be interested to hear counsel for Petitioner's response to our concern about the blue iguanas.
All right, why don't we turn to counsel for Petitioner? We'll give you another couple of minutes.
Thank you, Your Honor. Your Honor had asked whether or not there was a difference as to the legal acquisition as it related to the CBW registration and as it related to the export. My understanding from a review of the decisions that were rendered by the agency was that was the linchpin upon which really both of these applications were denied.
Counsel, would you help us? We're all puzzled at what the significance of the denial of registration. We understand the denial of export, but what is the significance of the denial of registration in real terms? What happens?
I think Your Honors were hinting around it.
I don't think we're hinting.
No.
We're absolutely puzzled. We don't know.
No, I was being somewhat polite to the extent that I believe, based upon what my colleague said, the animals, they're not legally acquired. So if they're not legally acquired by the agency's determination, and that lack of legal acquisition prevents my client from exporting them, in the same vein and along the exact same parallel track, they cannot be transferred to another zoo as was suggested, because that transfer would basically negate the reason for denying its export reason based upon legal acquisition.
That's what Judge Rogers pointed out.
And
So what happens to the blue iguana? Do they still stay at your client's location even without registration?
Based upon what my colleague said, I believe the inevitable answer is, which he refused to provide, is they get destroyed.
That can't be true.
Well, he didn't, he said I'm not legally allowed to withhold them.
I mean, this is what's
Well,
this
yeah,
is
I thought he was saying, excuse me, Judge Katsas, he was saying, well, the agency has discretion as to whether it brings an enforcement action. But, yes, Judge Katsas.
I mean, if they get destroyed, then that's harm, which is a separate ESA violation. If they don't get destroyed, that's continued possession, which the government thinks counts as collection, which is a violation. So what do you do?
Your Honor, I look at this and I say, here's an agency, and this is what the whole basis of our position is. It's arbitrary, it's capricious, and it's absolutely unreasonable for many of the reasons that are the concerns of all three of your honors.
Yes, but you're not answering nobody's answering the question, what happens to the blue iguanas?
No, he answered it.
I believe they get destroyed.
That can't be correct.
I don't know, because
that's certainly, can I go back to counsel for the government? Are you saying it's likely they'll be destroyed? I'm asking counsel for the government.
No, Your Honor.
Can you assure us they won't be destroyed?
I think it would be highly unlikely that they would be destroyed. It'd be hard for me to believe that. Unfortunately, what I'm struggling with here, Your Honor, is we don't know what the agency will do in its discretion here.
That's my point. That's the only answer you have.
Exactly, Judge Rogers.
The society has hanging sort of a sword of Damocles over its head. So one day the agency shows up on its doorstep with an enforcement action. Maybe a modification to the regulations is required.
Sorry, may I speak, counsel? May I speak, Your Honor? Perhaps. I just wanted to emphasize, there are 3 rounds of administrative review here. And the service was really doing all it could here on giving every opportunity to try to collect the information available to meet these requirements. Perhaps the regulations, perhaps the regulation could be challenged in the future. Perhaps some of these issues of the regulations might be taken up, but that just wasn't briefed here below or challenged below.
Does the service have some mechanism, and this kind of problem must come up, which is you find people who are unlawfully possessing endangered species. Is there some mechanism by which the service, if it chose, could come in and take possession and care for the animals, or send them to Denmark or whatever?
So, Your Honor, I'm sorry, but I wasn't able to familiarize myself with the specific enforcement provisions that the service would have available to it.
But in any event, are you saying that the denial of the registration itself has no enforcement aspect at all? The denial of the registration has no meaning?
Again, I'm sorry, Your Honor, but I don't have that information available to me right now. If the court, again, wanted supplemental briefing on this, the government would be happy to submit it.
I guess the question is, clearly before us is a challenge that the denial of the registration renewal was arbitrary and capricious. And that's why I raised the question as to whether the agency views these requirements differently for export and registration. And I thought that might be hinted at in your brief, because you repeatedly criticized petitioners for responding to the agency's request with one submission as opposed to responding separately as to the export, separately as to the registration. But I gather that is not your position. And so the question is, was it arbitrary and capricious for the agency to reach the conclusion it did here when, so far as we're being told today, it is possible that after the registration, the society has no authority to continue to maintain these iguanas that are on Appendix 1, and it has no way to prove what the agency is requiring. And so the agency is essentially, what do we say, cutting off its own, I'll get the analogy wrong, but the point is it's supposed to be preserving and promoting and protecting. And that's not the result here. Because if you have wild species for which the current lawful or previously lawful possessor cannot show a bill of sale, then despite the preservation and enhancement desires, the species has to be destroyed.
Your Honor, I just want to clarify a few points there. So in terms of this action being consistent with the Policy of Endangered Species Act, the service has certain conservation mandates. And part of that is making sure that there's a well-administered captive bred wildlife program where individuals and research institutions aren't breeding potentially iguanas with parental stock that have been illegally required.
That's kind of right. Prospective... So the result of your argument is they have to be destroyed because nobody has authority to have them, because nobody can prove. No, Your Honor,
that's not the position of the service. That's not the position of the service.
Investigated, and it couldn't find anything to satisfy it that these iguanas were brought in lawfully.
The position of the service is only that a captive bred wildlife registration can't be issued because plaintiff failed to meet the criteria outlined under the permit. And also
I said that four times, and the point is, what is the conclusion? And that's what Judge Silberman has been zeroing in on.
What's the implication of the denial of registration? That has to be before us. I think the presiding judge should ask the government to come in, not necessarily with a new brief, but just a statement as to what the significance of denial of registration is, perhaps in 10 days. What happens as a result of that? Could we do that? Could we ask counsel to at least provide us with a statement as to what the legal implications of denial of registration are?
Judge Katsas?
With me.
Yeah. All right. So we would like a filing by appellees stating what is the effect of the denial of registration.
Yes, Your Honor.
And specifically, what happens to the 24 blue iguanas that the society currently possesses and has possessed for decades under registrations issued by the agency. And what do we want to say? A maximum of 5 pages. Today is the 12th. Presented to the court within a week. Is that possible? Be the 19th?
Yes, Your Honor, absolutely.
The only reason I hesitate, Judge Silberman, is I don't know what the implication of that is for the petitioners. And maybe we'll see.
Perhaps they should have the same 5 days to give their
Respond.
to give their understanding of what the denial of registration means.
So simultaneous filing?
Yes, I think so. Otherwise, we would drag it on too long.
No, okay. So you're suggesting 5 days? Giving them a week.
Well, whatever you say.
Counsel for appellant?
I believe, that, I mean, look, I will defer to the court as to the time frame that the court wants to impose.
All right, but you would have no problem submitting a statement. Say today is the 12th.
By next Friday?
A week from Friday. Yeah, that's sort of a week.
That'll be fine.
All right. And no more than 5 pages.
That would be fine as well. May I make one additional comment that was raised very early in the argument as part of my rebuttal, if I may?
Yes.
I think Judge Silberman pointed out that the Blair affidavit contained certain information that was in fact not hearsay. And upon rereading some of my own writings, I may not have written it as clearly as I probably should have. And I noticed that when I was preparing for argument yesterday and was going through some of the materials that were in fact part of the record. So specifically looking at JA 000175, which is in fact the March 2nd, 2006 affidavit from David Blair to Helen Wilson. The part that I believe the judge is referring to is where Mr. Blair says, I obtained in 1971 from Roman Nagel in Florida. That is not hearsay. That is coming from the individual and the maker of the statement himself. It's not being used for certainly any controversial.
Counsel, we already recognize that.
Okay.
Yeah.
I
Anything
think that meets our burden.
All right. So then by March 19th, counsel will submit a statement on the effect of denial of the registration to the society and regarding the iguanas listed in Appendix 1 currently in its possession.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. And we will await your filings. Thank you, counsel.
Thank you.
This court is now adjourned until Thursday, March 18th at 9:30 a.m.
Thank you.
Goodbye.